I'm not a lawyer, but there was something that happened on day 146 of the YSL RICO trial that I want to break down for you. It was right after Judge Whitaker said that Detective Dennis would no longer be able to testify in this trial, and she was trying to come up with the instruction she was going to give to the jury.
What I am proposing to say as an instruction is Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and should not have been mentioned. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case.
Now, of course, the issue with Detective Dennis's testimony was that he mentioned Diamante Kendrick had been previously incarcerated, which is typically prejudicial or a problem to tell the jury. But in this case, since that information was already going to come in anyway, the judge wants to tell the jury that it shouldn't be considered against any of the other defendants. The problem is with the RICO, it can be. Watch these clips.
So I was going to say that his prior criminal history shouldn't be considered in connection with any of the other defendants or any of the charges against them, but that's not actually true if it's an overt act.
But, Your Honor, I thought we discussed this. The overt act is coming in as an admission by Mr. Kendrick, which violates our confrontation clause right. That's the instruction the state was supposed to give to you when they were talking about the same thing,
Right,
overt
the
act.
conviction itself.
Right, and that's the instruction I tried to do. I cannot formulate it, and you asked the state to do it. It goes to Mr.
I mean, I'd
Ryan.
love for both of you to at least come up with your best effort on it.
I may just continue speaking. That's why I believe that Mr. Ryan's jury verdict, Mr. Kendrick's conviction, Mr. Stillwell's conviction, there might be one more, the guilty pleas should all be kept out of this trial because somebody like me, Mr. Williams, not a convicted felon. He can't cross any of these people unless they testify.
So remember, I'm not a lawyer, but I'm going to try and give you a very broad, general description. So just follow me. Think of there being 3 boxes that have to be checked for everybody in this trial to be found guilty. Box number 1 is, was there an overt act done? Box number 2 is, did the person who did the overt act do it in furtherance of the conspiracy? And box number 3 is, are there other people that are a part of this conspiracy? Those other people don't have to have committed the overt act from box 1 and 2. They just have to be people that the state has proven are a part of the conspiracy. So a good example in this case is Rodalius Ryan. Rodalius has already been tried and convicted of a previous unaliving, and the state is using that unaliving and conviction as an overt act. So that means box number 1 could be automatically checked for everybody when they submit that conviction into evidence for this trial, which is what they're planning to do.
And y'all are planning to prove those as to the defendant who's convicted with their convictions, but are you doing anything beyond that?
No, Your Honor, and I think that was what Ms. Love was working on as far as crafting instruction, that it only goes against the defendant who's conviction. It only goes against that defendant, not the other.
Even as an overt act, even in consideration of RICO.
And I think that is where, as I say, we've been trying to word it, and Mr. Steele and I have had brief conversation, figuring out the best wording.
But do you agree that they can't, even if they find that overt act with regard to Mr. Kendrick or Mr. Stillwell, it normally would be that if you find that any of the co-conspirators committed an overt act, which then they would have found that as to these people if they believe the conviction, then all you need to find with regard to the rest of the co-conspirators is the rest of what's required for the RICO violation.
Now again, box number 2 is, can the state prove that the overt act was done in furtherance of the conspiracy? So if the state can prove that Rodalius Ryan committed that unaliving in furtherance of the conspiracy, that means box number 2 would be checked for everybody. And then box number 3 is proving that the other defendants in this trial are each a part of the conspiracy. So this third box is specific to each defendant. And in this case, the conspiracy is YSL. And the state has been trying to use a combination of ways to try and check this box number 3. For example, some of the plea deals that have been entered where co-defendants have said YSL is a gang and members of that gang wipe their nose or use the color green or say slime. And then the state shows maybe an Instagram picture of Jeffrey Williams wiping his nose or another defendant saying slime. That is them trying to show that these other co-defendants are each a part of the conspiracy, which would check box number 3. And that's why Judge Whitaker was struggling when she said a defendant's criminal history shouldn't be held against the other defendants, because in the case of a RICO, it kind of is.
And so how is it not in some way considered? It's not necessarily considered against them, but it checks a box that has to be checked with regard to each defendant that somebody committed an overt act. Okay, here's somebody who committed an overt act. And so it checks that box for the what's required for RICO.
Which is why Brian Steele was arguing that any previous convictions or guilty pleas should not be allowed in, because it's an automatic check to box number 1, but also because of a confrontation clause issue. Confrontation clause meaning he has the right to confront or cross-examine these witnesses.
I mean, and it may be that it does have to be some other overt act with regard. I don't see how it can't, how you get around confrontation clause, you know?
That was our position, because there's no way a highly intelligent juror like we have is going to be able to follow this gymnastics.
So if, for example, Diamante Kendrick has previously pled guilty and that guilty plea is being used to check box number 1 as an overt act, Brian Steele says he, as the counsel for Jeffrey Williams, has a right to confront or cross-examine Diamante Kendrick about that plea, because that plea is now being used against Jeffrey Williams. But the problem is Diamante Kendrick is a co-defendant in this case. And as you probably know, defendants have a right to not testify in their own trials, and that decision shouldn't be held against them. So Brian Steele can't demand Diamante Kendrick come to the stand so that he can cross him, even though Diamante's guilty plea is being used as an admission against Jeffrey Williams. Did you follow that? So Judge Whitaker actually instructed the state to come up with some sort of instruction to give to the jury regarding all of this, and that hasn't happened yet. It sounds like they're leaning towards telling the jurors that any overt acts that include a guilty plea or a conviction can only be a checkbox against the defendant that was convicted or accepted the plea, but we'll see. Hopefully I explained this in a way that made sense, but if you're a real lawyer and want to correct anything, please feel free to comment below. Also, I'm not saying the state's winning. I never said that. I just wanted to break down what Steele was arguing on day 146. Okay.